Hi, my name is Darcel Lobo, and I'm an attorney and owner of Dow Law Firm located in the South King County area, and wanted to speak with you today about garnishments, and in particular, what type of income cannot be garnished. We'll start with Social Security. If you are receiving any income from Social Security, whether it's for retirement or disability, that income cannot be garnished unless you owe money for student loans, child support, or any kind of federal tax debt. Otherwise, your credit card companies, medical bills, things of that nature, they are not allowed to garnish those types of income. So again, Social Security income from disability or retirement. In addition to income from Social Security, also your VA benefits, generally speaking, cannot be garnished to collect, again, for credit card debt, medical bills, things of that nature. But if you do owe child support, any kind of student loans or tax debt, it is possible that income could be garnished for those purposes, but otherwise that income is protected from garnishment. In addition, if you receive income from child support, that income cannot be garnished. If you receive unemployment benefits, that income cannot be garnished. As well, if you receive any kind of income or support from the state, that income cannot be garnished. Otherwise, any other sources of income, whether it's wages as a W-2 employee, or if you are an independent contractor as a 1099, or if you are self-employed, your income can be garnished to repay your creditors after they've received a judgment against you. Generally speaking, creditors can garnish up to 25% of your income. If you owe any child support, the DSHS can garnish up to 50% of that income to collect and pay for any past due child support. If a creditor issues a garnishment against your wages, that garnishment is valid for 60 days. So once they send it to your employer, it will stand in place for 60 days, and then it will lapse, and the creditor will have to reapply for another garnishment after those 60 days have passed. If there is a judgment against you, you'll want to do what you can to minimize how much cash you have in your bank account, because they can garnish and freeze any amount that is in the bank account, again, except for any kind of Social Security or things of that nature. But generally speaking, a creditor can garnish the full amount of the balance in your bank account at any point in time once they have a judgment against you. So you'll want to operate on more of a cash basis until you have that judgment resolved. If you've been served with a lawsuit, but there isn't yet a judgment against you, you'll want to ensure that you pay attention to a specific deadline for you to respond and file an answer to that lawsuit. Generally speaking, you have 20 days to respond to an answer from the date that you were served. An answer needs to be filed with the court clerk and also submitted to the plaintiff in that lawsuit, whether it's by fax, email, or by mail, or preferably you do it by all three methods. If you have been issued a complaint for an eviction, that is not a 20-day period, and it can be much shorter, so make sure you pay attention to the date in the summons for you to reply by. If you are facing a lawsuit or a garnishment and want to discuss what your options are, please give our office a call. We'd be happy to speak with you and discuss what the options are and advise you as the best option. Our number is 206-408-8158. Thank you.